Thank you very much, Professor Adem Sezer. Now we are starting the afternoon, the last session of the afternoon of the day. Before Professor Tove starting the presentation, Eren Sezer will read the CVs of the professor. Eren?
Thank you, Professor. Can you hear me?
Yeah.
Thank you. So I would like to present Professor Tove Malloy's CV to you, and we are very fortunate that she has accepted our invitation to speak today on a very crucial topic that is sometimes overlooked. So Professor Tove Malloy is a political theorist by training, and she's an expert on a variety of areas. She specialized in minority rights in international law and international relations, and her expertise her areas of expertise cover major international organizations, the European Union, as well as many individual countries. And she has actually acted as experts in these bodies. She has been called upon for expert advisory opinion by the Council of Europe, the European Commission, and many local and national governments. And her research has been funded by the European Commissions and many governments and private foundations. She has previously taught in Denmark and Italy, and she is now a professor at the University of Flensburg. Previously, she served as director of the European Center of Minority Issues in Flensburg, Germany. And in addition to her academic career, she has also served in the Danish Foreign Service in very numerous positions, and she has represented the Danish government in many international fora on post-conflict resolution for Rwanda, Bosnia, transition and development for Albania, as well as on indigenous affairs issues. And she has a doctorate from the University of Essex in the UK. And she used to be a member of the advisory committee to the European Framework Convention for the Protection of National Minorities. And she has also served as gender equality rapporteur to the Council of Europe. So we are very grateful that she has spared her time to share her knowledge and expertise on her topic.
Thank you very much, Eren. Professor Tove, the floor is yours.
Well, thank you first very much to the organizers for inviting me. It's a great pleasure to be invited to speak to your summer school this year. And especially because you've asked me to speak on a topic which I find to me, it's very important at the moment that we are living in, but also more generally, of course, it's a part of human rights law, which is fundamental. But I have the last couple of months really tried to look into this for various reasons, and I will try to explain this. And if you will allow me, I will share a PowerPoint. I hope I can make it work right now. So I hope you can all see it. Okay, so good afternoon to all participants. It's a great pleasure to be able to speak about this particular topic, which connects basically the COVID-19 pandemic with the right to information. So this is what I am investigating at the moment, because I find it, I find it interesting in the particular situation that we are in, because the right to information, of course, is a well-known topic to students of human rights, but in connection with COVID-19, it's a new constellation, I believe, especially in connection with minorities and vulnerable groups. And although I will focus on these vulnerable groups and minorities, I think it's a matter of concern to everyone, actually, and certainly everyone with special needs. So my background in minority rights, of course, has led me to this. And as I have said several times, it's still work in progress, and I'm very much looking forward to comments from all of you if there would be time. So I'm also arguing that specifically with regard to minority rights, governments have overlooked this in these last months of sending out a lot of COVID-19 information flow. I believe that governments have in fact gone back to the simple equality concept, if you will, and totally forgotten that there are certain groups and vulnerable groups that require special treatment in order to make sure that they do not become the first victims of the pandemic. So the problem has been has come to me because I have seen a couple of groups that have actually pointed this out very well in the beginning of the pandemic. And especially this NGO, Translators Without Borders, already in March this year, put into focus the issue that many members of society were facing in accessing and understanding the new situation. Most minorities and vulnerable groups had problems accessing, of course, the instructions given by governments because they did not understand them. Most instructions were issued in the dominant language. And early on, a few governments took the time to make sure that information was translated. We did see some sign language interpretations popping up, but even these were not a given in all countries, and at least in the beginning. But as governments became aware of the issue, they did begin to translate information into, let's say, the main languages, the large languages. And only later did they realize that there were also many small language groups and immigrant groups in society that only understood very little of the dominant language, for instance, and prefer to take instructions in their own language. But language was not the only issue. This group of Translators Without Borders also pointed out that the literacy of many vulnerable groups remains low in many countries. Vulnerable groups are often not able to access and use media. Whether this is mainstream media or social media, it can be a problem. And finally, there are many groups that do not trust the authorities because the government or the country, if you will, have a long history of corruption. This makes it difficult, not just for minorities and vulnerable groups, but also mainstream population groups to accept whether the information is reliable. So there was also another organization later in the process, another organization that raised the flags about accessing and understanding COVID-19 information. And this was a large NGO in the United States, the Asian and Pacific Islanders in America. They actually wrote a letter to the leaders of the two political parties in the US Congress in July 2020, so very recently, in which they reminded them that it was not just a matter of language and understanding. They were concerned about the deaf and the blind members of society who simply need very specific help to be able to access and understand information about the pandemic. So at the same time, of course, there was also great attention to the matter by international organizations. So these NGOs were not entirely alone. And if you go to the websites of these international organizations, you will find somewhere on their website, there has been messages addressing this issue, which I'm also trying to investigate a little bit for our discussion today. So the question of this lecture, and there are quite many, but I promise you that I will hopefully provide some answers to some of them. And the purpose here is really to understand what is at stake for these groups. And of course, to hope that they will not get sick and die. I promise that we should be able to understand better what is the right to information, and information important, of course, important in the fight against the COVID-19, but also what is exactly COVID-19 risk communication, because I think that needs to be deconstructed a bit. And how do we make informed decisions about COVID-19? And I think this is where I'm trying to take the next step into how the right to information actually functions. So what are the responsibilities of governments in this regard? What does international human rights law say? I'll try to talk about this. And how do states provide national COVID-19 risk information? How have they been doing this? And then finally, what are the criticisms of national approaches? I've already indicated this, but I'll get back to it towards the end of the lecture. So I will start with the right to information. This is not only because the right information is one of the fundamental rights in the universal and global human rights regime, as it was established after World War II. It's also because the right to information has now become much more closely related to democracy. The right to information has always been a key, of course, in non-democratic societies to try to transform these into democracies, or if peaceful transformation is not possible, to throw the dictators out. But, you know, secrecy is the dictator's friend, openness is his enemy. The right to information was considered so important that when the former South African President Nelson Mandela was drafting their new democratic constitution, he made certain that this one was the first that was included. Mandela understood that it is a lack of information and a lack of knowledge that allows systems such as apartheid to thrive. With information, citizens can better secure their democratic rights. Allowing people to seek and receive public information serves as a critical tool for fighting corruption, enabling citizens to more fully participate in public life, making governments more efficient, encouraging investment, and helping persons exercising their fundamental rights. The right to information also allows citizens to participate in setting priorities and in decision-making, to hold their governments accountable, and to assure equal treatment and equal justice. And it provides citizens with the ability to become good citizens. Many democratic governments have adopted specific legislation on the freedom of information. We have many examples of this, and even incorporated, as we heard with South Africa, in the Constitution. So first, let's look at the right to information quickly. It is important to remember that the right is a derivative of the Speech Acts in international human rights law. These are the right to freedom of opinion and the right to freedom of expression. Well, what does it mean to be a derivative? It means that a right can draw morally on other fundamental values in the system of human rights law. Freedom of opinion and expression are considered amongst the most fundamental rights, alongside, for instance, the right to life. Being a derivative right also means that it is more likely to be an instrumental right. By instrumental, we mean that a right helps us achieve some fundamental values, such as the right to life, to happiness, and in our case today, a good health. Instrumental rights are therefore utilitarian in that they focus on maximizing our happiness. The opposite is a non-instrumental right, or what experts call an intrinsic right. The right to life is an intrinsic right in that it does not need to have any supportive right to uphold it. It's a high value and a value of importance. We also say that intrinsic right protect the rights holder directly, whereas the instrumental right protects the interests of the rights holder. And therefore, the general argument would be that the right to COVID-19 information is instrumental. On the other hand, one could also argue that the right to know about COVID-19 and to understand what to do to avoid COVID-19 is closely linked to the right to life. Because avoiding getting sick of a virus that kills many people is perhaps more than an instrumental need. So just to continue a little bit on this line, this is of course an academic debate and I will not spend much time on it today. But you should remember that accessing and understanding information about how to avoid getting the coronavirus is closely linked not only to the right to life, but also to other non-instrumental rights. The first one that comes to mind is the right to health, of course. How do vulnerable groups living, for instance, in shanty towns without running water, how do they ensure good hygiene? And if they don't have enough rooms in the house to quarantine, how do they avoid the virus? And how do vulnerable individuals hold on to their jobs and livelihood if the pandemic results in a massive economic depression? What about the groups that work the jobs that nobody else wants? Statistics have already shown that minority and immigrant groups who work in the so-called frontline jobs are the first to catch the virus. So there are many aspects that we could discuss regarding instrumental versus intrinsic. I leave it to you individuals to pursue that argument. If you find it interesting, there are also scholars who have written about this aspect in connection with the right to information. For now, I want to talk about how the right to information empowers all of us. So how do we as individuals feel empowered by exercising our right to information? First, the right to information, of course, helps us gain knowledge. And knowledge is empowerment. The more we know about our society, the more transparent the society is. As we know more about our society, we become aware when something is not good. When we are aware that something is not good according to our common moral standards, we can act to make it better. This means that we can gain, that if we have gained knowledge that allows us to claim that changes should be made, and especially when something becomes unjust, it is important to be able to claim that it should be corrected. In other words, when we are aware of something unjust, we can exercise our rights to bring about justice. The same can be said about having the freedom to claim that injustice, that injustice is corrected, should be corrected. Corruption is considered a problem of transparency, but it's also a problem of coercion, pressure, outside pressure. If a system is corrupt, it often ends up forcing unjust rules onto innocent people. So finally, we can say that knowing about bad things in society and claiming our right to eradicate, eliminate unjust situations enable us to make others accountable. So claiming our rights because we have access to them means that we can hold others accountable if they behave incorrectly. And the bottom line is that the right to empowerment, the right to information empowers us because it allows us to make the right decisions, informed decisions. But how do we make these? First of all, we must have physical access to the information. This is obvious, and most people actually think first of access when they discuss the right to information. This is also what we find in human rights law. However, you also need to have cognitive access to the information. It means that, and what does that mean? That means that you understand what the information is telling you. In order to have cognitive access, you must be able to read, perhaps, maybe speak another language than your mother tongue. And you must have some skills to transform the information into your own situation. This means that the information may need to be interpreted into your situation through consultation with people in different society groups, leaders of these groups. Sometimes it's therefore necessary that representatives of minorities and vulnerable groups are involved in the process of producing the COVID-19 information. In other words, interpretation is needed if people are illiterate and only understand, for instance, pictures. Interpretation is needed if people have a disability that prevents them from hearing or seeing the information or the pictures. Interpretation is needed if people do not understand the language of the message. And it is needed if the instructions in the information are not compatible with people's cultures and traditions. So participation and consultation in assisting, preparing the information is here important. In other words, there can be many reasons why a simple piece of information may be very difficult both to know and understand, such as keep a distance of 1 meter from all people at all times. If any one of these situations occur, it is likely that a person may not be able to make an informed decision about his or her next step. So, why does it matter in a situation of pandemic that we make informed decisions? I mean, this is obviously a question that's easy to answer. But we need to understand that COVID-19 information falls into a category called risk communication, or it's information about risk to our lives that can result in death. It's therefore, it can be complicated information about health issues. How do we know that we're infected by the virus? What should we do when it happens? Do you understand the health terminology that the government and its experts are using? What are the tools that you have perhaps already in your home? What are the tools that you need to get? Where should you direct your questions and your requests about this? But also it is important that you learn why you have to do this. Not only for your own safety, but also for others. You must be able to understand why your actions impact on the lives of others. So COVID-19 risk information is also very much a political message about responsibility. But then the question is, who are the responsible parts in this? Let's look at who are the actors and how they become responsible. This table is supposed to show the mechanisms and functions which ensures a person the right to public information. You're all aware that with each human right, there is a relationship between the rights holder and the duty bearer. In this case, the rights holder is a member of a minority or vulnerable group who needs to be able to make an informed decision about the virus and COVID-19. The duty bearer are the public authorities who provide the public information, usually produced by governments and government agencies. The facts that we are talking about, public information means that, of course, it must be made available. In other words, it cannot be kept secret. It must be made accessible, meaning transmitted through all relevant channels by authorities or agencies working for the authorities, such as public media in this case. It must be legitimate, meaning misinformation is not allowed and the government is responsible for ensuring that it's reliable and valuable information, valid information. In order that we all receive the information that has been made available, it must be transmitted through the media or social media, etc. So next, the information that we consider legitimate must be legitimate because it comes from our government, but it must also be factually correct. And finally, the crux of the matter, as pointed out earlier, is that the information must be understandable so that we can make these informed decisions. So now I'm going to turn to international human rights law, and we have established that receiving information and understanding is not a simple matter. Indeed, it's not a given that governments comply and do everything in their power to ensure that we're all well informed. This, of course, is why international human rights law has taken initiative to make governments responsible. And in this section, I will go through the most important aspects of human rights law in relation to the right to information. And we start with the very beginning, because the first time we hear about the right to information was actually in 1946 in the UN General Assembly Resolution 59, calling for an international conference on the freedom of information. This resolution was adopted during the UN's very first General Assembly, and it was adopted unanimously. This shows how important the issue was already in the beginning of the creation of human rights law, even before the Universal Declaration was adopted. But of course, the Declaration eventually included in Article 19 the right to information. And as you can see there on the screen, it also means that there should be no interference in trying to seek and receive, impart information and ideas, etc. But if we go back to our history of the right to information in the UN, we see that then some years later, in the International Covenant of Civil and Political Rights, again in Article 19, the right is repeated. And again, it's basically this freedom to seek and receive and impart information that is the core. But also other aspects are included. What we see here, observations regarding how to receive it, that it's regardless of frontiers, it's either orally or in print, it's in the form of arts or through other media of choice. So here is already more meat to the bone regarding the right to information. And throughout the years and the history of the UN and later UNESCO, which actually picked up very strongly on the right to information, there are many documents and situations that continue to address this issue. What is noticeable is that these speak mostly about access to information. So we have to get all the way to 2010, when UNESCO held a conference in Brisbane in Australia, which culminated in an interesting declaration on the right to information. And here I only show the preamble, because I think it sums up very well where then the international community and the international human rights regime has arrived at. Many of the aspects so far discussed regarding the various ways that the right to information can empower people and how to attain and understand information. So it goes further than the early traditional documents. But remember, now we're in 2010. So we have basically a half a century where many situations across the globe have been invoking the right to information, but it has not often been provided, perhaps in the sense that it could be understood and used in an informed decision-making process. So we see that it has not always been provided in an adequate, good, reliable, and understandable way. Of course, we can move on to jurisprudence. And again, the right to information has been addressed many times in the UN jurisprudence. All of these provision access to information. However, getting to the general comment, and of course we can discuss whether it's jurisprudence, but it's very helpful what we see in the general comment 34. Because here actually it deals with the rights of minorities actually, and it connects to the right to information and to the need to adapt information to culture and traditions. The main purpose of this clause in the comment was to secure participation for minority groups in matters that concern their existence. It requires governments to consult with minorities in all matters that seriously affect them, and consultations are a means to provide some interpretation for minorities in their right to information. So consultations promote understanding. But if we move on to another part of jurisprudence, the European regional approach, we find the same result, that access is the main aspect that is addressed in the case law. One interesting development in the European region is, of course, the Council of Europe's adoption in 2009 of the Convention on Access to Official Documents. And this is actually it's the only legally binding treaty to date on the right to information, but still it focuses on access. The EU has issued one directive on the right to information in criminal proceedings in 2012. But although EU directives are binding for the member states, they're not always implemented by the governments. And again, we see that the jurisprudence and the new instruments, they address access, but not understanding. So I go back to the UN history, because I didn't take the time before to point out the the UN Convention of the Rights of Persons with Disabilities. And this is really a convention that is far more helpful in understanding the right to information in the way that I'm trying to develop this argument. So in the Convention on the Rights of Persons with Disabilities, we find for the first time help in how to approach the problem of the right to information for members of vulnerable groups and minorities. Already in Article 2, we find definitions on both the concept of communication and language. We see here how the convention is very detailed as to what tools can be used to ensure that information is understood by vulnerable groups. This is very helpful to our aim of this investigation into COVID-19 information because it says how it should be developed and how it should be delivered. And another article of the same convention is even more interesting. Here we find detailed suggestion as to what is necessary to take into consideration when transmitting information to persons with disabilities. It clearly shows that governments are responsible for interpreting and adapting information to the needs of the recipient, no matter what it takes. I think it's clear from Article 21 that governments cannot get away with just a few simple translations or sign language. So I move on to language rights, especially language rights for minorities, because we have in the European regional system some good examples here. Some of them are here on the screen. They represent both hard and soft law. But the European Charter on Regional Minority Languages from 1992 is particularly helpful in providing guidance. It's Article 10 of this language charter, and I'm sorry for all the text. You can look it up at the Council of Europe website, of course, but Article 10, Section 1 provides the right to use minority language in contact with authorities. This is the key. You also find this same right in the European Convention, the European Framework Convention on the Protection of National Minorities. The thing is, in the language charter, it's much more detailed how it is, how it can be transformed into domestic law. And the same charter, again, Article 10, Section 3, provides that services should be in minority languages. And if we turn to translation rights in connection with the right to information, the field is quite diverse here, the field of human rights, that is. The right to translation, as I'm sure many of you know, became a standard already in the Geneva Conventions after World War II. The main international human rights instruments then incorporated the right to translation afterwards, and you find it in the European Convention on Human Rights, in the ICCPR, as already mentioned. This was, of course, an experience from the war that gave the impetus to make sure that in certain settings, people could receive translation. The settings were, in the case of prisoners of war and other incarceration situations. Later, translation became recognized as necessary in the labor market to ensure that, for instance, indigenous people and migrants were protected against misunderstandings in between them and the labor employer. But we should note here that the settings are very specific. There's no mention of translation of public information in times of crises and pandemics. However, again, the European Language Charter, Article 10, is very helpful because it requires that authorities should make sure that translation is available to persons speaking minority languages in connection with interaction with authorities. So it even tells governments and authorities that they may have to recruit translators if needed. The problem, of course, with the language charter is that it has only been signed and ratified by very few countries. Only 25 countries out of the 47 member states of the Council of Europe have signed and ratified it. And more importantly, it's not a human rights instrument. It doesn't protect the rights of the individual speaker. It protects the languages. So it's really only helpful in terms of how it explains to us what authorities can do in order to make the right to information more accessible and understandable to minorities and vulnerable groups. But I remain quickly here with the right to information and the right to translation. Just to summarize, most of the documents we've talked about are relevant in the search for translation. However, they are confined to these specific settings. Translation to assist asylum seekers is included in the EU directives, and this may be helpful in the COVID-19 situation, because asylum seekers have often arrived recently. They have not had the chance maybe to learn any languages other than their own still, and they certainly need to receive the same information as the rest of us, even if they are in a situation of being a refugee in a camp or however they are placed. So we must ask, what about including the areas of pandemic and other major crises in the right to information? Major crises can also be earthquakes or mudslides, weather disasters. Nature crises are not mentioned in these documents. And I just quickly go back to our discussion on non-instrumental rights in connection with the right to information, because we must remember that the right to life or the right to health or social and economic rights are very much dependent on the right or a right to translation. So now I'm going to turn to national language policies and how do states actually manage linguistic diversity. And many states, I'm sure you know this, have official language policies indicated in the Constitution. However, there are also many states that do not address the issue of an official language or of official languages in plural. Some states like Belgium have 3 official languages, with the 2 main groups being the French and the Flemish speakers, and a smaller German speaking group. And another good example is Finland, where you have a main language group speaking Finnish and another small group speaking Swedish, but both languages are official languages according to the Constitution. A very similar example is Canada, where the main language is English and a smaller group is French speaking, but both languages are official languages in the Constitution. Then we have a bad example with Estonia, where there's a large Russian minority. It's similar to Canada, about 25% of one language group. However, when Estonia became independent from the USSR, the parliament immediately decided that Estonia would be the one and only official languages. And language policies can also be regional. Some states have opted for one official language, but allowing bilingualism or multilingualism in specific regions. regions where there may be more language groups residing together. A good example is Alto Adige or South Tyrol in northern Italy. That region has 3 official languages: Italian, German, and Latin. Spain is another good example where several regions have both Spanish and a regional language as official languages. But when it comes to immigrant languages, the story is very different. Immigrant languages are rarely recognized as official languages, even in the United States, where Spanish is used widely, also by the authorities. There's no recognition of Spanish, nor is there any official language in the US at the moment. Another interesting example is Australia, which has adopted a policy of multiculturalism. However, the government has not adopted a policy of multilingualism. The major part of the countries in the world do not accept multilingualism as a paradigm, even though there are many languages and language groups living within the territory. So scholars of language have argued that selecting a language policy is not just an instrumental issue. It's both very political and very psychological. So I will take the time for a little detour here. I hope I am okay on time. The Canadian scholar Alan Patton has developed a theoretical understanding of how states manage the issue of linguistic diversity. He has examined policies of a number of countries that come up with two categories of approaches followed by states. So the one is official multilingualism and the other one is language rationalization. His benchmark has been whether language is recognized, and there are different ways to recognize a language. Not all require legal recognition. Public acceptance is also a way of recognizing a language. Nor do they require equality between languages, but each of these categories of approaches represent actual examples that Patton has identified in reality. And let's look just at these two quickly. The first category, which is official multilingualism, he identifies 3 countries: Canada, Belgium, and Switzerland. He also argues that this is actually a paradigm which is adopted by the EU institutions, not the EU as such, because it's not in the EU countries, but the institutions in Brussels. The main characteristic of this paradigm are that official communication is offered in several languages. There is symbolic affirmation of minority languages, which leads to respect and a sense of worth for the speakers of these languages. There is an understanding that language and identity are linked and need to be recognized. Government policies that include these 3 aspects of linguistic diversity can be characterized as proper in terms of official multilingualism. And the outcome is that no one language becomes dominant. There will be regular use and maintenance of minority languages. This means that there's no need for convergence on one language, which Patton considers a form of assimilation. And equality between the languages will be achieved. According to Patton, however, it is very few countries that will go this far. So he speaks instead about another type of policy paradigm, which is much more prevalent, the language rationalization approach. This is the preferred paradigm because it contributes to nation building, it prevents parallelism and fragmentation of societies. He also argues that it's preferred by governments because it promotes social mobility. This is because allowing too many minority language communities can result in ghettos and parallel communities. If people live separate lives, they're less likely to integrate socially and economically. Since the economy is seldom divided into communities, but is universal across society, it can become difficult for members of language communities to find jobs if they do not master the main dominant language. Another aspect that concerns government is the democratic deliberation and decision-making. Societies with one dominant language will have one public sphere in which the democratic debate takes place. This is important to governments that want to hold on to power, of course. Another argument which is related to the common democratic debate is efficiency. It is simply cheaper to function and communicate in one language than in several or many. It is even argued that meetings can be conducted very quickly if only one language is used. Finally, proponents of this paradigm argue that one official language promotes a common identity. This is considered important for many reasons, but not least for securing social unity and peace. But you could also argue that it helps the officials to stay in power. So proponents of this paradigm will argue that it's necessary to create convergence around one language. One, even if it's a result of assimilation, the fact that some language groups and minorities may wish for their language to be equally respected is not relevant. Proponents of this paradigm simply do not think that equality of languages is important. So let's get back to the COVID-19 communication argument. So what is actually considered risk communication? By risk communication, we mean information that is vital for the entire population and the entire territory of a country. For this reason, it must reach all corners of the territory, and it must reach all adult members of society. When the pandemic broke, most governments chose to use public media and press conferences to announce sort of the initial policies, recommendations, and responsibilities. This means that overnight, the media had to take on a vital role in securing that information reaches all relevant individuals. This was in itself a change, because many countries have seen a privatization of the media over the last few decades. And with privatization of the media, it has very often eliminated the role of the media as responsible for transmitting public information. Of course, other tools were also included: websites, social media, and regular information material. Some media outlets have also used children programs, or governments have produced children videos to communicate to them about virus. And finally, creative communicative directors have developed videos for YouTube and other apps. So there's generally been a good revolution in means and tools. The problem has been that transmitting these in languages that non-dominant language groups and vulnerable groups understand has been somewhat disrespected. So to be fair, of course, many governments immediately employed interpreters using sign language at the press conferences. Many provided them simultaneously, others published it separately in a video after the press conference. After a few days, websites in foreign and minority languages popped up, and of course good. Traditional information materials also appeared in the main languages. However, as I've mentioned, immigrant languages were not always covered. One country actually has seen an initiative to adopt legislation ensuring translation. This is the United States, where a Democratic Congress woman from New York proposed legislation on a COVID-19 Language Access Act. This was in April 2020. Let's take a quick look at this. Basically, it talks about the federal agencies, how they, if they receive federal assistance, money, then they must translate all their English information into a number of languages, a minimum of 7 days later. And in the act, the minimal relevant languages included are a number of immigrant languages. Unfortunately, from what I have been able to research, the proposal has not moved 1 inch out of the first stage. So this is really the only example I've been able to find in this short time. So the other aspect that I really want to touch upon, and I have just a few slides left on this, as you may recall, we mentioned earlier that adaptation is a major concern. By adaptation, we can mean many things, but here it means that COVID-19 messages to specific communities who may have difficulty in understanding the messages should be adjusted to the needs of these communities. We know from research during the Ebola outbreaks in Africa that without a clear understanding of the specific cultural situation where communication about risk takes place, translate efforts were maybe in vain, if not even counterproductive. Translators Without Borders have found that information like you have to go early to the Ebola treatment center to be cured may simply frustrate people, because what does early mean? It varies from culture to culture. So having a method that complies with the grammar and the lexicon of a given language is only the beginning, according to these social linguist experts. It's only the start of a translation work. The primary goal of risk communication is that people change their behaviors based on the new information they receive. So the point is not that the message is merely understood, but the point is that it's understood and accepted by as many people as possible. For this to happen, one must keep many aspects in sight in addition to the narrow linguistic ones. Words and metaphors that are chosen matters. The meaning that a message will invoke by the simple fact that of believing, of being delivered by certain institutions or individuals. So it's very important who delivers the message. The use of certain channels and styles can be critical. And so these are all factors that affect how people will respond to the message. And experts on on a blog called Language on the Move have advocated that authorities should adopt an approach that puts the particular community and its social cultural context at the center of the translation effort, rather than the message itself. This is called a community-centered approach, which entails empowering the community itself as the producer of the message. For instance, according to experts from Translators Without Borders, one cannot understand the Ebola outbreak in Africa without clarifying, for instance, its relation to colonial and post-colonial medical practices across the region. Moreover, it's difficult to understand the health crisis without looking at the prevailing social imaginaries like culture-specific ways of interpreting the world, to understand vernacular rationalizations of the event, and involving culturally and socially informed expectations. They also argued that only community members will know how to deliver a message that has the best chance of being accepted by the community. The bottom line is that risk communication about COVID-19 must be community-centered rather than message-centered. And finally, the experts also caution that along with the pandemic, the world is experiencing an infodemic of misinformation about the causes and treatments. And in such context, the credibility of a message must be evaluated from a local perspective. For instance, the experts argue that most people on Earth don't know what the WHO is. Or even if they do know it, there are many who have mixed feelings about it, or even have a vague sense of what it even represents. This means that a message branded by the WHO is not likely to have a great chance of being taken seriously in many communities around the world. So this is just a recap basically of what to remember when communicating with minorities and vulnerable groups. It's important to remember that vulnerable groups often have lower levels of education. Translating literally from A to B does not always work. The illiterate and the blind need particular tools to understand the message. Understanding of health issues varies from culture to culture. Another important aspect has been that communities rely heavily on face-to-face communication, especially if the young have to translate informations to the elderly. That imposes the risk of contamination right there within the family. For this reason, experts are calling for greater participation of community leaders if we want to ensure that we eradicate the coronavirus. So before I wrap up, I'd like to just provide a few recommendations from these sociolinguist experts within this network of Translators Without Borders. And they recommend, as you can see, that policymakers listen to the needs of minorities and vulnerable groups, that they adapt communication to their need, and it's vital to understand the context of minority communities and their past. And finally, they urge policymakers to make sure that there is funding set aside for communication, risk communication, because this is often the last point on the budget of many national budgets. So in concluding, COVID-19 has a serious communication issue, I believe. We've seen this is the problem that many governments have with reaching out to minority and vulnerable groups in a manner they understand. All human beings have a right to information. There are plenty of instruments in international human rights law that provision this right. The right to information focuses on access rather than communication and understanding. This poses a problem of securing that minorities and vulnerable groups understand the COVID-19 information. Many minority groups actually have a right to information in their mother tongue. Unfortunately, only about 25 European countries are bound by this human right legally. Language policies seldom include translation policies. National governments do not provision legislation and funding for translation. Translation also means adaptation to cultural needs. Translation must not be from A to B. It must also adapt to the cultural context. And finally, COVID-19 risk communication must have legitimacy. Minority and vulnerable groups do not always trust the information that comes directly from government. They would rather trust their own messengers, transmitters. So remember, global COVID-19 is global. It doesn't know borders, it's everywhere, it's colorblind, it's race neutral, it's everybody's enemy. It needs to be managed carefully and it needs good communication. So thank you for your attention. And I look forward to questions and perhaps discussions.